June the 11th, when they arrested me, June 11th, 2008, they put me in the jail, the city jail, and like I say, they were loading up the 16-foot trailer with all this stuff. And I'm on the mat there in the jail, I'm pondering the situation, and like, why is this happening to me? And what came to me is that probably hundreds, if not thousands of people had cried out to our Heavenly Father in prayer for relief from this oppression. And I mean, it's serious oppression there when you got like police doing stuff like raping 30 women. You know, I mean, it wasn't just me, it was all over the place there. So what came to me is that it's like I'm the point man in fixing the situation, and whether I like it or not. And so I was pondering that situation. The cell door opens, and this well-dressed black man comes in, flashes his identification, FBI, and says, "I'd like to talk to you for a few minutes." And I'm like in a little bit of a state of shock. He announces that, he says, "We have your complaints and Judy Scott's complaints and David Baugh's complaints." And he said, "I want you to know that the Jacksonville police have asked the FBI to assist in the search and seizure." And he said, he said, "I initially didn't want to do that, but he said, we're doing it." He said, "I just wanted you to know, Mr. Fox, that we have your complaints, and we have separate people working on the complaints, and other people are working on the search and seizure." And we had a pleasant conversation, and he left. The chief of police, by the way, was outside the door, eavesdropping on the whole conversation. And I didn't know that at the time. I was told that afterwards. Anyway, now, in the jail, me in the city jail, transferred me to county jail. They were altogether 3 days in custody. And then friends bonded me out. And now Judy Scott takes me, and we make a beeline to the Tyler office. And like I say, this black gentleman, top guy in the FBI, and I said to him, they're trying to murder me. And he said, "Mr. Fox, they're not going to kill you." And I said, "What do you mean?" And he said, "I've already told the chief of police that if anything happens to Mr. Fox, he's number one on the suspect list." But doesn't that tell you something? I mean, even he knew the jeopardy that I was in, that he would speak up and tell the chief of police, "If anything happens to Mr. Fox, you're number one on the suspect list." That's the kind of crime syndicate that we're dealing with out there. You understand? So, anyway, we covered that too, Mr. Heidman? No? All you have to do is you take what they've done before, put it in a criminal complaint or other stuff, and then get it done up by notarized and filed in the public record. And then
I'm going to do that. They got an order against me. I can't file anything without this idiot looking at it.
Okay.
A magistrate judge.
But you're not filing it. You take it into them, or either you or somebody else, and you put notice on there. So you're giving them notice of what is filed in the public record. And the public record, you guys know, Federal Rules of Evidence 902, right?
Well, it's evidence in the record. I know all about it.
Yeah. So just putting them on notice like that is going to get their attention. And in McGlattery's case, it got their attention sufficiently that they dropped the case right there.
Well, let me explain what happened. Go to the microphone.
We're restricted in the time here. If you can make it quick.
I did the David Miller stuff. They have a problem with David Miller. problem is they can't beat him. That's a real problem for them. So,
If you may excuse me, but David Miller is not the be-all and end-all. And when he says that you have to do it in grammatically correct English, the fact of the matter is that you can go to the law library and see what the Supreme Court writes their stuff in. And they write their stuff in plain English.
That's right.
The way everyone else understands it.
that's right. But they, when John Roberts was confirmed on September the 15th, 05, a senator from Oklahoma asked him, "Do you understand the correct sentence structure, communication, syntax?" He says, "Yes, sir, I do." He said, "Will you hear cases in it?" He said, "Yes, sir, I will." So that was a blow, and Leahy immediately jumped up and said, "That's enough of this stuff. We're not going any further." Anyway, I did that with Miller for a while. And I put a case in, and they had no response for it. And he dismissed it. You can't dismiss it, first of all. It was in Title 42, 1983. You can't dismiss it. It has to be heard or settled. So that was with a judge up in I had another case with a judge up in Spokane. They appointed this other judge as a temporary judge because their docket was over. And they put that together. And he's the one that came up with the vexing litigator stuff. Now they've been hammering me with vexing litigator. And just recently, we put in quite a pile of documents. We lifted this case to federal court. And we lifted the second case that has a bearing on this as a necessary party. So they jumped on this business that Judge Windmill, his name is, had said back 2 or 3 years ago that I may be a vexing litigator. I'm not going to go to their court and listen to this crap, so I didn't go. So he then let it go because it was, he turned around and said that he was going to dismiss the case. We can't dismiss the case, but he did.
So what's the point, please?
Point? What?
We need a point.
I'm getting to the point. Just wait a minute.
Yeah, timeline.
The point is that now they've come up with this same thing again, but they did a switcheroo. When I lifted that, I become the prosecutor. In other words, I'm the petitioner. So he's now changed it around. I denied a magistrate judge, but they sent me a letter to a post office. The post office sent it back to them and said they didn't have, it was undeliverable. It was deliverable, but they didn't try to deliver it. That gave them an excuse because the post office sent it back to dismiss the case. So I wrote them a letter. I wrote them a document, put it in the record that the case was not dismissed, it was still active. And I put in a continuance of prosecution. So now they combined the two cases under a new case now and put the magistrate judge in front of the case, which I had denied already. And the magistrate judge then says, well, I guess we'll just have to let the chief federal judge handle this, but you are going to honor his motion for pre-filing review. Now, he went on and on and on. Nobody can I show this. I'm not supposed to have anybody know about it or send it in, and it's a pre-filing review order. And that's the long and short of it right there. I'm under a pre-filing review order, which means that they can dictate the evidence that's before the court. I have no way to get evidence before the court unless I do something and I don't know what to do.
I didn't get all that. Can you repeat? I'm trying to help, but I didn't understand a thing.
Could he ask the court to have that in writing, that he cannot defend himself like that? I mean, he cannot.
I got an order, it's in writing.
Yeah, I mean,
Okay.
doesn't that already prove that this whole thing's a shenanigans?
Well, yeah, their whole
I mean,
thing.
right there, I mean, he already won based on that?
Their whole thing is a scam. It's a matter of being able to get past all of their shyster shenanigans. There's various ways of doing this stuff. So I'll describe one, and that's with the media and how this came about. This is the real deal. In Jacksonville, they brought 4 drug charges against me. I don't do any drugs. I don't even take aspirin. But you know what they did? I was describing to you from the beginning. They broke in at the dental clinic. So, and then they wind their way through the whole building and come to me. They had dental antibiotics from the dental clinic that had been closed. And they attribute that to me. While they know that they knew before they even knocked on the, before they attacked the door, that was the plan. And so, they got these dental antibiotics charges against me. And the Jacksonville newspaper put on the front page, the Jacksonville police have requested the media not to disclose to the public what kind of drugs these are. Can you imagine trying to stand in the back alley selling dental antibiotics?
I don't think you can get high off that.
And I mean, the whole thing was preposterous, but they were carrying on like it's for real. And they put a picture of this stuff on the front page of the newspaper. And at the pawn shop next door, this guy is about dying laughing. And he says, because they got this tray and they got these drugs in prepackaged plastic bags, and right on it is the name and address of the dental clinic and all. And what drug dealer puts, his name and address and phone number on the package? And there's on the front page, 10,000 pills found, Robert Fox, bad guy. And so anyhow, the judge was Craig Fletcher, and he's the one that signed the search warrants, and now he's the one going to adjudicate the case against me. And the guy is like unbelievable. And so first I moved to recuse him, and they blew that off. And I figured, okay, I'm going to get real serious now. I'm going to disqualify him. And anyway, they passed that to. Well, let me say this. This was the actual event where they had me in the courtroom, and David Bob passed me papers that he had made copies for me. That I had, I'd created them and stuff I mailed out, and he typed it up and made the photocopies, and now all I needed was my signature. So I'm signing these things, which involve written criminal complaints against Judge Fletcher. But before I did this, I'm there in open court, and verbally I'm making criminal complaints against Judge Fletcher. The prosecutor jumps up and calls for a recess. He dashes to a phone to call Judge Ovard, who's the administrative judge over 34 counties in Texas. When Texas is a big place, 254 counties altogether. So while the prosecutor is away, David Bob passes me the papers. I'm signing them, and I get the clerk in the court to file stamp them, and I hand them to the judge, and I put the copy on the prosecutor's desk. He's still at the phone, and the judge is aghast that I'm bringing written criminal complaints against him with a file stamp in his own court, you know. And Randy Kelton stands up in the audience area and declares that he's taken criminal complaints to the grand jury. And they're about, you know, coming unglued, but they're trying their best to maintain their composure and carry on. And the prosecutor comes back and says that, you know, it's cleared with Judge Ovard and they're to continue and blah, blah. And I wrote to Judge Ovard trying to explain the situation. And of course, you know, I told him I made an offer of proof, which yesterday I explained to you. Offer of proof is a very serious matter. But Judge Ovard was blowing it off. And so, I put in, I sent a letter to Pat Shannon with the American Free Press. And, you know, he called Judge Ovard, and, you know, the question comes down to something like this. When, where, and how did you acquire the authority to overrule the United States Supreme Court? Speak.
Speak now.
Our readers would like to know. We're a national publication. And so what happened, in Cherokee County, the fax machine starts up and off rolls one page. Effective immediately, Judge Fletcher is off the case and Judge Nelms from Dallas is appointed. Signed, John Ovard. So you may have to go over their head.
Where do you go?
Well, you could, with them, I'm in the Fifth Circuit of the Federal Court of Appeals, and yours is what?
Ninth Circuit.
Ninth Circuit, okay? So you've got to send something to the Ninth Circuit about the situation. The shorter you can make it with getting the message across, the better. Okay? And
I could do a habeas corpus, produce a body of law.
Okay.
Produce a body of law that says that they can do this.
but they can do what?
That they can issue a pre-review of filing order. That won't work, huh?
Well, I mean, there's other possibility is that you can let them do their pre-filing review. But if they rule that you can move forward, you got no complaint. And if they don't, then, you know, take it to your Ninth Circuit people, or contact your congressman, or contact the media, or do something like that, and hit them from another way. There was a guy on the East Coast. What he did was he took a van box truck, a big one, like a moving van, and had it, you know, the sign painted on it, Judge so-and-so, Butcher of the Constitution, parked across the street from the courthouse. Now, I asked people, what do you think that cost? Because, I mean, the judge looks out the window and sees that truck there. You know what happens? He just picks up the phone and calls either the police or the sheriff's department and says, out of here. Okay? So what do you think that cost? Any guesses?
How many calls have been trial?
Pardon me? Well, most people actually say, well, it would cost him a couple $100 for the towing and impound. Now, this guy was closer. He says 20,000. Why did you say 20,000?
Well, because it's not going to be cheap. All right, you take the judge off.
Okay? You were close, but no cigar. Here's the deal. It was either 200 or 250,000. that the judge had to pay for violating the First Amendment free speech.
Oh, good. That is the First Amendment violation.
There you go.
What they want to is the First Amendment violation.
In Cherokee County, there was like a town festival coming up in the courthouse, one of these old courthouses in the town square, and the festival was going to be all around it, all that stuff, and all the people coming together. Well, I got 4 van body trucks, one on each side of the courthouse, painted with the signs, you know, and I guess they weren't happy. We were on CBS television news and all of that. The police went and checked each truck for the license plates, registration, VIN number, all of that, and they didn't touch any one of them. And my guess is that the reason was because they had my phone tapped and knew that if they touched any of those trucks, that the next thing would have been the free speech lawsuit. And it would have been a lawsuit for the free speech issue if they would have taken any of the trucks. So figured that they had the phones tapped. I have other reasons to believe that, and the evidence and so on. And going back to the thing with Ovard, yeah, that was one of the things that I believe that Pat Shannon made an issue of, was that I had put in my documentation against Judge Craig Fletcher. I was making an offer of proof, and that's supported by the Supreme Court case Haynes versus Kerner. And if I haven't put that in some of the paperwork that I handed out, I'm going to dig up that site and send it to you in email. So, anyway, I guess we'll move to the thing about, going through the criminal process and share with you some pointers that we haven't done so far. First thing is, if there's some rumblings, like instead of having just a normal IRS agent on your, hassling you, if they flash their badge and say they're CID, Criminal Investigation Division, you know that you're headed to potentially an indictment. Okay? Now, it isn't just IRS, but it could be any situation where you think you're potentially headed toward an indictment. I will give you a real life example. A bunch of guys in Arkansas had what they considered like a militia, and they had a clubhouse, and they had machine guns, and they liked to shoot up old cars in the field, make a lot of noise, and have a lot of fun. And everything was great, except that the FBI and the ATF didn't like that idea. So they mounted a raid on these guys all at one time. I mean, a massive manpower, and everybody got attacked. The clubhouse got attacked, and everybody else got attacked at their homes. And they got the machine gun seized and all that stuff. And the head guy was Wayne Fincher. And I think that the fact that Wayne Fincher had a multi-million-dollar chunk of real estate was a factor in his case. But anyway, Wayne Fincher got himself a good attorney. And the guy charged, it was like $25,000 for a case acceptance fee. So he looks at the case, I guess the indictment or something, and determines whether or not he wants to accept it. And if he accepts it, then that's what the $25,000 fee is for. And then Wayne Fincher can start paying him to do work on it. Is that sweet enough? $25,000 case acceptance fee. Anyway, the bill was run up to like somewhere approaching $100,000. In the process, the other guys could see that it wasn't looking good for them, and they were getting calls or whatever from the FBI, and anytime law enforcement, this just popped in my head, anytime law enforcement asks you questions, what pops in my mind is what old George Gordon said. There's 3 rules. Keep quiet, don't say anything, and shut up.
Did you say that again?
So anyway, it's best not to tell them anything, really. And, everybody thinks that they're going to talk their way out of it. It doesn't work. They use every word you say against you. They have a way of twisting it or construing it. And next thing you know, you're up to here, and then they'll even say, well, you lied and you're like Martha Stewart and you need to go to prison anyway. Because Martha Stewart didn't go to prison for insider trading. She went to prison for lying to a federal officer. So anyway, so what happens is these guys are really apprehensive about what's going to happen to them. And I was contacted, and I said, okay, here's what we do. Send a letter to the grand jury foreman, care of the U.S. Attorney. In the federal, unlike, say, Dallas County, I know where the grand jury is. It's in the basement of the Frank Crowley Courthouse. And they have actually 2 grand jury rooms. And you can actually physically go there and tell them, I've got criminal complaints I need to address the grand jury. And you can potentially get in there. They will resist, but you could potentially get in there, I did. But in the federal system, you don't know where they meet, you don't know when they meet, you don't know who the grand jury foreman is or anything. But the U.S. Attorney is the one who controls that. So the letter is addressed to the grand jury foreman, care of the U.S. Attorney, address, etc. Okay? Certified mail. And so in the letter, declare that have exculpatory evidence. Now,
I know which one this is. Good stuff.
you like that? You did?
Yep.
So the letter lands on the desk of the U.S. Attorney. And now the question is, what does he do with it? Well, curiosity gets the cat. He opens the mail.
Big mistake.
He's opened somebody else's mail. That's a crime.
That's number 1.
That's number 1 crime. Yeah. And then when he sees that you have exculpatory evidence, that's the last thing he wants to hear. And you want to appear before the grand jury to present the exculpatory evidence. Well, he doesn't want that. In an IRS case, for instance, if you know your stuff and you have something that can, prove your innocence, or, they just don't want it there. Okay? They want to be able to prosecute you. They want that merit pay increase and all of that stuff. How many people don't know about the merit pay increase? Okay? They get a bribe. Obama gets $35,000, the judge gets $25,000, the prosecutor gets $15,000. They get a bribe from the International Monetary Fund. The IRS is not a part of the government. and they have no business being in the federal court in a criminal case against you, period. It's tantamount to Federal Express knocking on the door of the grand jury or the U.S. attorney and saying, so-and-so owes us some money. We'd like to have them prosecuted criminally in federal court for not paying their FedEx bill. Well, where are they going to go with that? You know what I mean? Take a hike. But because it's their pet, the IRS, because they're all communists there, they accept that, and they accept the bribe, and they prosecute. I mean, what else can you call it? They call it a merit pay increase. And it's right in the law. But the only ones who get the merit pay increase, best I can find out, are the ones who are prosecuting IRS cases.
That, by the way, real quick, can be done by a third party as well, not necessarily by the defendant. A third party can go offer exculpatory evidence to the grand jury.
Oh yeah, thank you for mentioning that. My friend Eric Leiter from Hawaii sued 8 federal grand juries for not indicting him. And people say, what? How can that be? What he did is he discovered that, the problem of getting to the grand jury in the federal system is pretty serious. And so it goes like this. If Eric and I were at WACO, before the annihilation, and we had high-power telescopes, and we look through our telescopes, and we see that, like that famous picture of the guy from Vietnam. He's down on his knees, and the guy puts a gun to his head and blows his brains out. And many people have seen that picture. With the gun, the smoke from the barrel, and the brains flying out the other side. That's a famous picture. Anyway, if we were to see that, and our scopes are so good that we could read the badge numbers on the ATF agents, and we're appalled by what we see, and we go to the federal courthouse and to the U.S. attorney or the judge, doesn't matter which, but we'll say we go to the U.S. attorney and we say we're eyewitnesses to murder of the Branch Davidian, blah, blah, and we saw the ATF agents who did it, and we read their badge number because we had really good scopes. We read their badge numbers and we wrote them down. And these are the guys that did it, and we're prepared to identify them in a lineup, and so on and so forth. And the U.S. attorney says, don't you ever come in this office again. Get the hell out of the building, and I don't want to ever see you around here again. And if you are around here, I'll have you arrested for trespassing or whatever crap they want to come up with. And we step out in the hallway, and it's like, well, how do we get the truth into the court or anything? Well, Eric Leiter figured it out, and it is that he comes in with his confession, and he confesses that he was in conspiracy with the ATF agents that murdered the little children at Waco, etc., etc., and he confesses to the conspiracy. And because he's involved in the conspiracy, that he has an automatic in to the grand jury to tell him about his co-conspirators. But I think they sensed that coming. And see, if the grand jury investigated, they would find that, yes, the little children were killed, and the only ones who were there that could have done it is the ATF, because they kept everybody else out. The news media couldn't even come in. They had to have those gigantic lenses on top of their big trucks to be able to see what was going on there as best as they could. And they couldn't see the other side of the building or anything, So anyway, they had that figured out. So the grand juries would never let Eric Leiter come in and explain any of this stuff. And they kept him out, so he sued 8 federal grand juries for not indicting him. It's pretty amazing. And actually, Eric Leiter, his girlfriend, and Jeff, a friend of mine, and myself, we worked all night on stuff for the Branch Davidians. And as the sun came up, and we're sitting at Denny's having breakfast, it was a matter of deciding who was going to take it down to WACO. And Jeff and I took it down to WACO, and we tried to get it filed in the federal court, and the FBI were running interference and all of that stuff. I went down to WACO 7 times. I was arrested twice. It's a heartbreaker that they killed all those people. You were going to say?
No, I'm actually swatting these flies.
Oh, okay. Okay.
I was just going to ask you to repeat that. Did you say the crap? I can't remember. I forgot my question. The exculpatory evidence. Did you say that the merit increases were actually written in the law or something like that?
The what?
The merit increases that the prosecutors receive for prosecuting IRS
Right.
cases. Did you say that was written in the law?
Yeah.
Can we have the citation or reference for that, or did you say it and I just missed it?
Is it the IRS manual or is it in the statute?
It's in statutes. It's in the United States Code. I have the stuff, and if you'll be kind enough to remind me later, like, I don't have it right here, but I have it in a computer back in Texas, and it could be part of the stuff I emailed to you.
To all of us, you mean?
Yes, all of it.
No, just me.
Write it down.
Well, remember, everything is negotiable.
We all have your email address.
Answer.
I don't think you finished that segment.
Oh, no, I'm not finished that segment. You,
I mean, can we continue on with the?
yeah.
My question was, is you don't put the exculpatory evidence in the letter.
No, you don't need to.
So clarify that, please.
You don't need to, because it's best that you don't. Even if you have exculpatory evidence, it's best that you do not alert them to what you have. You know, because it's like, say this, you got, say, 3 items of exculpatory evidence, and they have a way to shoot you down on those 3. But while the letter's in the mail, you think of 2 more. But now they've shot you down on the 3, and they're not going to let you see the grand jury. You know? And then next thing you know, you're indicted. Well, so anyway, to go back to the situation with the guys in Arkansas, you know, the letter was sent, no contact was made with the grand jury. The FBI tried to contact, our guys in Arkansas, and tried to get them to acquiesce to this process. And they said, we never got to see the grand jury. We think that the U.S. attorney intercepted the mail, and that's mail fraud, and where your system is crooked, and so on and so forth, And the whole thing went away for those other guys. Wayne Fincher got 6 years in prison after he paid the attorney almost $100,000. He gets 6 years in prison, and the stuff that I figured out for these guys finished the case off. The whole thing was like shot because they couldn't do anything. And in another situation which involved the IRS, the guy was contacted by the FBI as to what exculpatory evidence he had. And he says, wait a second, you're the FBI. I never wrote to the FBI. I wrote to the grand jury. Did somebody open the grand jury's mail? Because that sounds like mail fraud. And he said the FBI was hyper anxious to get off the phone. It's like, well, we're going to send a letter back. We didn't have anything to do with this. So that's like pre-indictment stuff. And I should probably describe something else too that's very important. A fellow, this has been related to me by somebody else. I wasn't there, I didn't physically see this, but it all makes sense and you'll understand why. So a guy, got in front of the grand jury, and the first thing he does is figure out who the
Foreman.
who the attorney is. Okay, so the grand jury are dressed like regular people, and attorney is dressed in the suit, right? So he says to the attorney, "Are you a part of the grand jury?" Well, the guy answers truthfully that no, he's not a part of the grand jury, but he tries to make his deal that he's, an assistant U.S. attorney or whatever. And the guy says, "You're not a part of the grand jury, so you can either leave, or if you're going to stay here, you sit over there, and you don't make any faces or signals." And he turns to the grand jury foreman. He said, "You're the grand jury foreman, and what are your questions for me?" Stuck. Because the attorney is the one who dreams up the questions and asks them. And the grand jury sits there like they're being entertained. Okay? When he asks the grand jury foreman, "What questions do you have for me?" The grand jury foreman is stuck. He has no questions. And so then the guy says, "Since you have no questions for me, but I do know about the situation, here's what it is." Bing, 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 bing. No build. Have a great day.
That's the greatest inside information. That's the greatest inside information.
Yeah.
Yeah.
Robert, what do you do if you ask to go before the grand jury and then the prosecutors denies that? Denies your appearance to come before the grand jury?
Well, this is why I was saying it gets sent by mail and certified mail. So that,
What if you've done that and they still deny it?
did they send you a letter, Susie? Well then, that's another thing for,
Not the grand jury, the prosecutor.
yeah.
They didn't send any letter.
Microphone.
I requested, they called me, the prosecutor called me and said, "We are maybe going to indict you. Don't know for sure if we're going to or not. But I understand you have exculpatory evidence. And if you have any, this is your opportunity to turn it over to me." And I says, "No, I don't think so." I said, "I do have exculpatory evidence, and I want to take it and present it to the grand jury." And he says, "No, that's not possible. You have to turn it over to me." And I says, "No, I
This
don't."
is a conversation on the phone.
Right, and so
Okay, this is what I recommend to people you need to have a recording device at your phone. I mean, just as a routine precaution, but for this kind of situation when you could be involved in litigation like this, you need to be able to, when you pick up the phone, click on record. At the very second that you know that you're talking to one of the systemites. Because if you had that conversation recorded, then you could bring it into court and,
He'd be toast.
he'd be toast because, isn't that right, Mark? He'd be toast.
Well, I have it on letterhead. I mean, he sent me letterhead. and told me also that.
Oh, well then,
That's even better.
that's even better. You need to put that in a public record or something and bring it in as 902 evidence when you go for your sentencing.
Absolutely.
That destroys the case.
Should you always request writing, never a phone call? You should always request and then write it.
Absolutely, and she got it in writing.
I had a question about that. You said that we should always record the conversations. What about the admissibility of that evidence? In some states, I know that the recorded party, the party being recorded, is supposed to be told in advance in order for it to be admissible.
Okay.
Can you elaborate?
You're right. You're hitting on something here, and it goes like this. Different states have different laws, but in Texas, we don't have that problem. That's why I was just speaking like I was about recording everything.
Arizona's the same.
So I was in federal court, and as a matter of fact, it was Judge Jerry Buckmeyer, the one who ex parte deal sent me to Springfield. And let me say this, there was 2 inmates that were locked up. One of them, at first they were together, then they separated them, and then I won my case with the State Department, and I still took phone calls from other inmates, and one of them says, his name is Dwight, and he said, Dwight says to me, he said, Werner may be being turned by the feds and going to testify against me to get himself a better deal. And he said, Robert, you could record the conversation with him and ask him these questions. Is it something you want to bring in about that?
Well, I want to go back to the grand jury thing. When we're talking about that grand jury, when you go before the grand jury, excuse me, we were called in for the grand jury, and that prosecutor started asking all the questions. And I did, like you said, excuse me, I came here to speak to the foreman of the grand jury in the grand jury. And he says, well, you're going to talk to me. I'm going to ask questions here. I said, I believe you're not part of the grand jury. I think you should be over there sitting down or leave. He said, no, that's not the way it works here. You're going to answer my questions. So he started asking me the questions, and I said, well, I would like to invoke my Fifth Amendment rights to not indicate anything against myself in this case. So ask your question, and every time he asked me a question, I said, well, I'll stand on the Fifth Amendment on that. And so after about 10 or 15 questions, he says, well, ladies and gentlemen of the jury, apparently Mr. McBride is going to take the Fifth Amendment on every question, so there's no sense asking him any more questions. And this is where I dropped the ball, and I didn't know it. I turned around, and he looked at the jury and says, does anybody in here have any questions of Mr. McBride? And this lady jumps up and says, well, I guess ain't no sense us asking him any questions if he's going to take the Fifth Amendment on everything. And I turned around and left. And I should have said, ma'am, ask your question. I haven't heard your questions yet. All I've heard is from this dumbass.
Exactly.
And I didn't come here to answer his questions. So ask your questions and let's see if I take the Fifth Amendment, because I came here to tell my story. And I didn't, and I blew it. So if you get the opportunity, remember that. Don't answer his questions, but ask the grand jury to ask you the questions and answer them.
Can you just order, just get over there and sit down?
I did that.
Order them?
I said, excuse me, you're not part of this grand jury.
Get out of here.
You have no business in this room. I came here to speak with the foreman of the grand jury and the grand jury. He said, that's not the way it's conducted here.
That's the way it's going to be now.